Talk Picture, proudly brought to you by New Guinea Table Birds.
Good evening. Thank you for joining us. We are here with Dr. Eric Kwa, Secretary and CEO of the Constitutional Law Reform Commission, and Mr. David Gonol, Assistant Registrar at the National Court and author of a new book on the underlying law in Papua New Guinea. Welcome to Talk Picture, gentlemen.
Thank you.
Thank you.
Sarah. Thank you.
It's our pleasure.
So we're here to talk about underlying law and its application in PNG. To start us off, I think we all need an explanation of what underlying law is. For many of us, the courts and the law is a whole new world. So can you please explain what underlying law is and how it is a part of the body of law that governs the country?
Thank you very much. Let me just explain what underlying law is. Okay, underlying law is a body of law developed from customary law and common law of England. If these two sources of law are not applicable, the courts can use certain provisions in the Constitution to formulate new rules and then apply them to a case. So the Constitution actually empowers the courts to develop that law, and that law can only be developed if no rule of law is applicable. Say, for instance, if there is no rule in the written law, say legislations or statutes, or if no such law is applicable, then the courts, especially the higher courts, the Supreme Court and the National Court, are empowered by the Constitution and the Underlying Law Act 2000 for them to look into customary law first. And if there is no customary law principle applicable, then courts can look into common law. And if there is no common law rule applicable, then they can formulate new rules. And such rules or laws principles of laws that courts develop, they become part of underlying law. Therefore, underlying law is a body of law that is developed by the higher courts, national and Supreme Courts, using these three sources of law.
Dr. Kwa, what would be the best way to explain underlying law in everyday language?
Okay, thank you, Sarah. Underlying law is a result or the outcome of a combination of two laws being put together by the judges in the National or Supreme Court. So let's take the example of a marriage that is broken down. So I dealt with a case where we had a lady from Medang, from Bogia, and married to a guy from Manus. So they got married in church. So that's called statutory marriage. That's under the Marriage Act. And then they went and they also did the customary rights. So they got married also under custom. And then they divorced. So the question was, which law were we going to apply? Are we going to apply the custom from Bogia, or are we going to apply custom from Manus? Or are we going to apply the Marriage Act? And of course, under the Matrimonial Causes Act, or we call it the Divorce Act. So which law would we apply in this case? And so in a typical case, the National Court will look at the statute law. So for example, it will look at the Marriage Act and then look at the Divorce Act and then say, well, I don't find an answer to resolving this marriage issue. So they go to the custom. And then they look at Manus custom and they look at Bogia custom. Well, both of them are not similar. So we need to arrive at a situation where we are able to give justice. So the whole idea is about justice. And so in that context, of course, the statute law does not have a good answer for the two parties. And then two customs are in conflict. So the court look at the common law. We call it, look at other cases from Australia, from England, and they look at a typical case, whether they can find some answers that will bring justice to these two parties. When they look at it, they find that there is no answer because this is marriage in Papua New Guinea. It's customary marriage. So they develop a new decision. They come up with a new idea. And they say, well, all right, because we looked at this common law, there is no answer. We looked at the statute law, there is no answer. We looked at the custom, but there are two conflicting customs. Now we will create a new rule. Now that new rule is called the underlying law. And so when we go back to a new case in the future, say for example 5 years time or 3 years time, and a similar situation arises where say the two parties are from two parts of Papua New Guinea, different parts of Papua New Guinea, they get married, and they come to the national court to seek a dissolution of their marriage, they will then refer back to the decision of the case in the Bogia lady and the Manus guy case. And then they will look at it and say, well, is it okay now? Or should we improve on the decision that was made maybe 5 years ago? And that's how they continue to grow or develop the underlying law. And that particular underlying law is what we call the law of Papua New Guinea, because it's been created by the judges based on a situation in Papua New Guinea. And so for us, that is the kind of body of law that we want to try and promote, because it reflects Papua New Guinea values, and it also expresses our aspirations. It's not based on some case in England 20 years ago, 30 years ago, 100 years ago, and we're trying to follow their ideas. This is Papua New Guinea. We need to develop our own character of law. That's what I might call it.
It's more or less reflective of Papua New Guinea's contemporary society.
Yes, definitely. You know, Papua New Guinea is changing all the time. Situations change, custom change, and so for us, the law must keep up with it. And how does that law keep up with it? In our case, the judges and the judiciary must make those decisions to keep up with the changing pace, changing customs, so that the law is evolving all the time. For us at the Constitutional Law Reform Commission, that's what we need to see. Is it happening? And we can discuss that a little later.
In other parts of the world, especially in Africa, they are also trying to codify their customs, meaning that they are trying to write down all their customs and then apply them in court as well. And that's number one. Number two, when you study history, legal history, you will come to realize that back in the 10th and 11th century, back in England, they lived in customary traditional societies and all this, so they had their own customary laws. So that's why back then they started extracting these common customs, and then they came up with the current underlying common law, which is now applicable all across the nation. So back in England, they started it, and even in Africa, I have done a bit of study and came to realize that these African nations are also trying to use custom in court as well. So in PNG, I think we now feel that, or our constitutional fathers, they felt that we needed a unique law. We need not to rely entirely on the English common law or the laws that we inherited from England, our colonial masters. So that's why they came up with this idea. So this idea I also see in African nations as well. So African as well as others, especially where they have a customary laws really active.
Right. So
Yes.
in the Pacific, do you see some other countries in the Pacific?
They do recognize their constitutions, and the laws do recognize custom. So I can see that element of underlying law in other regions as well.
So you've mentioned that the Underlying Law Act was enacted in the year 2000, it was supposed to give precedence over customary law. That's what I've read. How did you? What was the thinking that went into that, and why did the government feel like there should be an Underlying Law Act?
Okay, Underlying Law Act. Initially, it was a draft legislation back in 1977 when late Bernard Narakobi was the chairman of the Constitutional Law Reform Commission. So he came up with that draft, but that draft was not passed until the year 2000. So when you read that Underlying Law Act, you will come to realize that actually the Act is for customary law. There are provisions in the Act which say that customary law, in the event that there is no rule of law applicable in a particular case, courts must first consult custom. If custom is not applicable, then courts must also justify and give reasons why they are applying, trying to apply common law or the law that the case laws of England and other jurisdictions. So I come to realize that this law has a sense of an element of nationalism in it. We want to develop a law that is pure Papua New Guinean. All other laws we have, you're talking about constitutional law, customary law, torts law, all these other laws that we have, they were made in England and shipped them over to Papua New Guinea. But underlying law, made in PNG, in our very courtrooms, for Papua New Guinea. So that's why I also come to realize that these parliamentarians also shared the same sentiment. They wanted to see a Papua New Guinean law that will reflect Papua New Guinean values, Melanesian values. So that's why they first did. So the onus is upon us now to effectuate and to use it and to help develop this underlying law.
In the court, practically, do lawyers also rely on underlying law when they're making a case, or is it only applicable when judges are putting together a decision?
Okay, in this case, lawyers play a very vital role in the development of the underlying law. Judges and the courts, they are there. Basing on your presentation, they make a ruling. So if you present the custom, or if there's a case where you think that the customary law should be applied, then the lawyers have that duty to present that in court. So then courts, and then also present evidence as well. So what I come to realize is that lawyers, most of them are not presenting custom in court. The problem, I think, is that because custom is unwritten, lawyers are trained to quote the law in the books, and the custom is not written, and so it makes them difficult to prove it in court. So that's why they always resort to case laws that are already there. And then that is the problem I see. So this now brings into the scene the next question, and that is to compile all the customs, go out, survey, and then write all the customs down, and then put them in the book so they can easily make reference to such customs when presenting cases in court.
You're training lawyers, and so you need to start from someplace. And so in this instance, while I was at the UPNG Law School, we introduced a course on the underlying law. So we call it the underlying law. And that course was designed to help the young lawyers to develop their skills and the ability to present very good case scenarios for the court to develop the underlying law. The underlying law itself is not per se a piece of document that you can get and say, well, okay, this is the underlying law. The underlying law is a body. It's a body of law And that body of law is called the underlying law. And so, as David said, it's quite difficult to put your fingers. Say, for example, if you have a contract case, you can easily go to a bookstore in PNG or elsewhere and buy a law of contract book. And so you can easily pick up the principles and you present it in the courtroom. For the underlying law, it's really up to the lawyers to go and find custom and then present that custom. The courts will then use that evidence to develop that underlying law. And I need to just explain a little bit clear here that the body of underlying law is, it's like a case, a box. You need to fill that box in. And so that box is what we call underlying law. What is inside, we need to develop it. We need to pack it. Under the Constitution, Section 20 and Section 21 of the Constitution says that at a given point in time, the Constitutional Law Reform Commission will advise government, and then the Parliament will declare the underlying law. And so, at the moment, in our minds, we can see the box. That's the body of law called the underlying law. But what's inside, we don't know. And that's why it's quite difficult at the moment for the lawyers to put their fingers on a particular matter and then start to discuss the underlying law. And that's why, as I said, as a cycle, from the law school, we introduce this program. And then we hope that the lawyers that graduate will then be able to use that knowledge to now bring in custom and argue on custom and written law and try to balance it out. At the judiciary, they've also now introduced the practice directions on the development of the underlying law. And so from the law school, you got people who are trained now to use underlying law, and then you got the judiciary who has now issued a direction to the lawyers. If you come up with a case, first of all, consider whether we can develop the underlying law. If you answer no, then we start to look at the written law and laws that have been adopted in cases. We can look at that. We now are moving to another point where people like my office, we now need to start to identify those cases that the courts have now made a declaration or a decision which now reflects the underlying law. And so it's now for my office to start to assess all the cases. And so we have begun that we began the task of looking at cases since 1975. So from 1975 upwards, we have tried to review all the cases. We are now reviewing all the statutes, all the laws that have been passed in Parliament since 1975 to see whether the elements of custom that have been captured in the Acts of Parliament and whether the courts have now declared a body of law that we can now put our hands on and say, well, in terms of contract law in Papua New Guinea, this is the decision that now applies in the context of PNG, because that's a new decision that the courts have come up with in, say, 1980, and then that case, the lawyers are now following it. And so lawyers are used to citing cases. And so if a new decision comes out, then the lawyers always refer to that case. And then they begin to develop that body of law. So for example, in terms of criminal law, contract law, constitutional law, the law of torts, injuries. What have the courts said about custom in the context of the decisions? And for us, that's what we need to do. So as a cycle, as I said, as they come into law school, they train them. As they appear in courts, they tell them, this is what you must do. For me and the other law officers now, our job is to say, well, we have now found this, so you must quote this. And it's a cycle. It goes back to the law school. They use the cases, they use the materials, and they continue to educate our young lawyers on developing this body of law. So that's the kind of thing that we do. It's quite very interesting work that we do, because we're studying customs of different parts of Papua New Guinea, and trying to see how the courts have applied those customs in various cases. And so we pick up those cases, and for me and for David and for all the other lawyers out there, we hope that those information that we now generate can then be published. So now lawyers, the ordinary Papua New Guineans, parties who go to court, they can then access those materials and use that to now continue to grow the underlying law.
Mr. Gonol, you've written a book about the adoption and application of customary law in the country. Can you explain why you felt the need to write this book?
Thank you. I wrote this book. It has taken me some time to write this book. And the title of the book is The Underlying Law of Papua New Guinea, an inquiry into adoption and application of customary law. Okay, I as a Papua New Guinean, I should call myself a legal patriot or something, because I am so much in love with this particular law. I want to see, I'm not talking about the region, I want to see Papua New Guinea develop its own local jurisprudence or local law. Because I see that our problems are unique, our way of doing things are very unique, therefore a unique law will address our problems. My rough estimate is that about 98% of the legal principles governing this nation, they came from England through Australia. So you see, when you look at contracts law, you don't apply customary law, you don't find any Melanesian value whatsoever in there. So it's basically we brought it over from England and now imposing on us, Papua New Guineans. And sometimes it works and other times it doesn't. So I also, when I drive along, Waigani Drive, I see these Papua New Guineans gathering under the rain tree near Konitaige's hovel, and they resolve their problems and they live in harmony. I know that they are not using common law, which is applied in the courts. So they must be using a law. And what is it that they are using it? So I come to see that they are using customary law. And the Constitution talks about us using customary law to develop the underlying law. That is the impetus, that is the drive that has led me to write this book. And actually, I also give credit to God, because God has actually given me that wisdom and the ability to write, so I give Him the credit. And number two, that drive or that interest, that zeal to see Papua New Guinea develop its own law, body of law, or what is otherwise known as underlying law or indigenous jurisprudence. Because we do things our own way. As Dr. Eriko has just said, we have got our own unique ways. So those unique ways must be reflected in the laws that we have. And that law is the underlying law. So that's why I just wrote this book. So this book actually explains, it's 3 parts. There are 3 parts in this book. So number 1, it talks about a general introduction to underlying law. Number 2, it discusses cases in which customary law was discussed. I tried all of my best to discuss cases dating back to 1975 up until today. So cases in which customary law was discussed or underlying law was developed. Such cases, I also discussed them here. And then the third part, it's an appendix, so I attach all the legislations, relevant legislations, which talk about underlying law or customary law.
In Papua New Guinea today, you see this discussion between what is now recognized as human rights and then what some in our customs will see as going against, human rights and all. How do you've mentioned something in our previous discussion about unworthy law and unworthy customs and worthy customs. How do you see PNG legal system, filtering out filtering out the unworthy customs and keeping those customs that we see as worthy?
The law provides for all these things. The law itself has the filtering system, so you don't just adopt and apply all the customs. The law, the underlying law and the Constitution, Section 20, 21 and Schedule 2, they also provide for us to filter the customs, and then the good ones, we adopt them. The bad ones, there are other customs which are not good, which we don't adopt them. One good example is there's a case on one of such customs. It's a Miriam Willingel case. This case was decided in 1997. Actually, there's a custom in the Minch area of Juaga province. The custom is known as Ed Fay. So, in that custom, there was a young woman by the name of Miriam Willingel. Okay, that woman, she was a girl, she was attending school, but a tribe actually killed a man from another tribe. So their custom stipulates that when they pay compensation, they must also pay some young girls as part of compensation. So unfortunately, she was the one that they chose to pay as part of that compensation. And then it came to the attention of an NGO, and that NGO eventually filed a case in the court saying that that custom is against the Constitution, against human rights. So the case was decided by the Chief Justice, the current Chief Justice, but he was the ordinary judge back then. So the court decided that that particular custom of head fay was unconstitutional and against the Constitution, is repugnant to general principles of humanity. It's not good for humanity, and also it's not a good custom, and it's a legal custom. So we should not practice it. So it's against human rights. So you see, we have the laws there which are now filtering out such customs and only adopting good customs.
Does that
I discussed that in this book as well as other such cases.
Does that case now, is it now seen as a precedence where if head pay cases come to court, they would then use that to decide cases?
Definitely, it's a case precedent. If such a similar case comes to court again, then the precedent is already there. So this case now forms part of the underlying law, so the principle is there, and they will apply to other similar cases.
We have sufficient number of Papua New Guineans, both in the judiciary, at the universities, out in the practice, enough Papua New Guineans who are able to look at the TED lens, through the TED lens, and help our people. And I do not think it's a threat to existing principles of human rights, existing principles of law that we have. All we are saying is that let's try and promote, as David said, the good customs. Can we promote those values? For too long, we are relying on foreign ideas, foreign values, and then we are trying to adopt it in a way that we think it's ours. And we conflict with those mixture of ideas. Whereas if we are able to stand firm on our values, the values that have sustained our communities, sustained our people for centuries, if we're able to sustain those, and for me, instead of continually borrowing ideas from outside, can we offer new ideas, new insights to the rest of the world?
That was a very interesting discussion. Thank you so much, Dr. Kwa, Mr. Gonol.